So we have different approaches to multi-tiered dispute resolution, MDR, and different historical, cultural backgrounds.
Yes, look, let me give you an example of, if you like, a clash of arbitration and MDR cultures. And this was a well-publicized case in Hong Kong called the Kenai case. And it's an example of what it involved was an application in Hong Kong to set aside an arbitral award that had been issued by an arbitration commission in mainland China, right? But one of the parties wanted to have it set aside in Hong Kong. And the argument was that it would be contrary to public policy to enforce this award because there was the appearance of arbitrator bias. So the arbitrator was biased. And this is what had happened. First of all, at first instance, the court in Hong Kong said, yes, we're going to set aside the award because there has been the appearance of bias. But then it went to the Court of Appeal in Hong Kong, and the Court of Appeal said, well, we agree with this version of the facts here. Actually, our interpretation is that there are different cultural differences, and as an ARB-MED process or an MDR process, this would have been acceptable in mainland China, and so we will enforce the award, right? But it's quite an extreme case, and let me tell you some of the facts. It dealt with a share transfer agreement, and I'm just going to refer to my notes to make sure I get this right. So it seemed that there was an arbitration that took place in mainland China, and during an adjournment in arbitration proceedings, one of the members of the arbitral tribunal, so the panel of arbitrators, contacted a lawyer for the respondent, one of the parties, and then also requested another person, right, a third person, someone from outside, who was friendly with the respondent, right, the person they'd contacted, to come and meet with the arbitrator and the Secretary General of the Arbitration Commission at the Shangri-La Hotel over dinner, right, in the middle of an adjournment. So you've got one of the parties, an outside friend who the arbitrator thought would be able to influence this party, and the Secretary General of the Commission, of the Arbitral Commission. And at dinner, the Secretary General of the Arbitral Commission conveyed to the third party that, well, particular views. They said, well, while we think the share transfer agreement is valid, we actually think that this party, the respondent, would probably be well placed to offer the applicants, the other party, 250 million RMB. So the Secretary General encouraged this third party, Zeng, to persuade the respondents to adopt their suggestion of what would be a good outcome, a good way to resolve the dispute. So Zeng, the third party, tried to encourage the respondent to do this, to make the offer of 250 million RMB to the applicant, the other party. But the respondent said, no, actually, I don't think we'll do this, because what you've just said to me is that this share agreement is valid, but we should nevertheless make an offer, to the other side to make amends and have an amicable resolution. But I actually think if the view of the Arbitral Commission is that the share agreement is valid, well, there's no reason for us to offer any money to the other side. So thank you, but no thank you. We'll just go back to the arbitration, right? So off they all trotted back to the arbitration, which then resumed, and the tribunal made a decision and issued an award to the effect that the share transfer agreement, not valid. So they changed their mind, right? So it's the opposite decision to that was intimated during the Shangri-La dinner. So then, clearly the respondents were upset about this, and were then trying to suggest that the award could not be enforced because the arbitrators were biased, right? And this went to the court. So the applicants, who were very happy with the outcome, said, no, there's nothing wrong with this. This is an example of MDR, right? And in fact, what happened at the Shangri-La Hotel amounted to a mediation within the terms of Article 37 of these particular arbitration rules. And the rules permit that arbitrators can meet with parties and third parties and jointly or separately. And this is exactly what happened. So the applicants were trying to enforce the award in Hong Kong, and the respondent said, no, you can't enforce this award. There's mediator bias here. What happened was completely inappropriate, and so this effectively, the award is invalid. And so at first instance, His Honour Mr. Justice Reyes at the time agreed with that argument and said, this MDR procedure, if you call it that, has a number of unusual aspects. And here are some of them. The venue and the timing, namely dinner in a hotel rather than a formal venue. That's unusual to start with. The parties did not appear to consent to the time and place of the so-called mediation, and it's not clear whether the other party knew about it to even start with. And no one appeared to consent or have any say as to whether this third party, Zeng, was allowed to attend. The mediation was conducted by a non-presiding member of the tribunal and the Secretary General of the Commission. That was also very unusual. There was a lack of consultation around various other elements, and there didn't seem to be any direct consultation or discussion with the applicants in relation to the $250 million suggestion that they make as an offer. So, in fact, the mediators had asked the third party, Zeng, to work on the respondents and get them to make this 250 million RMB offer. And so all of these, this bundle of factors together, said His Honour Mr. Justice Reyes said, would at the least raise the perception of bias, right, in the eyes of the eyes of a reasonable person. And he also said something interesting. He said, the judge, labelling a process as mediation doesn't mean anything goes. There are appropriate and there are inappropriate ways of conducting mediations. The would-be mediator must ensure at all times, especially when he or she might act as an arbitrator later on, that nothing is said or done that could convey an impression of bias. Right? And he thought in this case, some things were done that could possibly convey an impression of bias. Anyway, so then the case went on appeal to the Court of Appeal in Hong Kong, and the Vice President of the Court of Appeal overturned the decision at first instance and effectively enforced the award. And what's important is, it's really just a different interpretation of what amounts to bias or perceived bias. The Vice President said that although he felt and recognised the unease about this particular MDR procedure and the use of so-called mediation in this case, he insisted that due weight should be given to the practices in mainland China. And if this was normal in mainland China and this was the cultural norm, then that should be respected in Hong Kong and in the Hong Kong courts, and therefore the award was enforced. So, what's really interesting about this case, I think, is a number of things. Is that sometimes it's very hard to decide what's appropriate or what's inappropriate in a multi-tier dispute resolution process, and there can be very strong differences and extreme differences among cultures. That's why my advice would be, if you are conducting an MDR process of any kind, if you are designing one, if you are drafting a clause, to be very, very clear about the intent, about how those processes, different processes, come together into one MDR procedure, and how the integrity of each process is maintained, so that you're not going to have court cases like this where you have a decision at first instance which is then overturned on appeal. In fact, you don't want to have any questions at all. You don't want your arbitral award to be challenged. You don't want your MDR procedure to be challenged at all. So you can't hide behind the label. You can call it whatever you like, but you've got to make sure that each element of your MDR process has integrity, right? And that this is in your design.
Okay. So the robustness of your BYO.
I couldn't have said it better, Alec. The robustness of your BYO. I'm going to steal that line.
Great.